This is Myths of Common Law Marriage, Part 3, Housing and Property Rights. We'll start by taking a look at some of the statistics involving families in the UK. 2017, almost 19 million families in the UK, a 15% increase from 16.6 million in 1996. The important statistic here is 12.9 million families are married and civil partner couple families remain the most common, with the cohabiting couple family growing the fastest. This can be seen in the third slide, where we can see an ever-increasing trend for the numbers of cohabiting couple families, whereas married or civil partner couple families and lone parent families stay at a relative constant over that 20-year period. Statistics provided by Office of National Statistics. The myth. Unmarried common law couples that live together for years share equal legal rights as married couples. This is false. This is categorically false under English law and Welsh law. Common law couples are not protected under property law in England and Wales. The length of the time that a couple spends together is not a consideration for the courts in England and Wales. I must preface this is slightly different to the rules in Scotland. Scotland, under Section 25 of the Family Law Act of Scotland, 2006, gives some power to the courts to provide rights and legal protection to cohabitants. The 3 points of consideration under Scottish law are the length of time the parties have been living together, the nature of the relationship, and the nature and extent of any financial arrangements or entanglements in place during that time. However, we would just be considering English and Welsh law for the purposes of this demonstration. So, what can cohabitants do to protect themselves legally? There are three options for cohabitants in this case. Be proactive. It is possible for cohabitants to draw up an agreement, which may not be legally binding in court, but can prove useful as an instrument to demonstrate, should a dispute arise, what the intentions were as a couple, as a cohabiting couple, if there is a dispute regarding how the property should be divided up. Ultimately, it will require another form of legally binding document, such as either a will or a declaration of trust that the courts will be able to rely on to demonstrate what the purpose, what the intention was for the cohabiting couple should their relationship come to an end. Probably the most important option for a cohabiting couple would be to consider becoming legally recognized. Couples don't have to be married traditionally in order to qualify for a legal formal relationship. Couples can become civil partners in order to gain the same level of legal protection as those enjoyed by married couples. So that presents itself as an option. We'll look at the two forms of major householding and see what rights are conferred to both cohabitants and married or civil partners in these cases. Now, tenancy. One married partner cannot eject the other from the matrimonial home without specific court instruction. This right is gained by all married partners, regardless of whose name is on the tenancy agreement. That is a protection you're afforded as part of your marriage. Married partners have the right to request the landlord can remove a name, but only may do so if both partners agree. This is a protection of intention, really. The intention when you are married is that the home you are resident in will become the matrimonial home. And a matrimonial home is a more protected residence than, say, a property shared by cohabitants. Married partners have the right to apply to court for tenancy agreement transfer in the event of a dispute. Um, yes, I mean, in the event that, for instance, both names were on a tenancy agreement at the time a marriage um, breaks apart, it is possible for the courts to arbitrarily rule on which of the partners has legitimacy of stay within the property. Uh, Fundamentally, common law partners hold none of these rights as tenants. Um, as a tenant, you are at under common law, you are at the whim of whoever's name is on the agreement in terms of protection. Homeowners, common law partner as a sole owner of a property has every legal right to stay in the home, and they can request that the partner leave the property, but uh, you cannot eject a common law partner if they are able to demonstrate a beneficial interest in the property. Now, the legal burden in this case is on the partner who is being ejected um, from the residence. It is their responsibility, therefore, to demonstrate to the court that they have a specific beneficial interest in the home if it belongs solely to one or other of the common law partners. Common law joint owners have equal rights to remain in the home. The only thing that may affect the rights to one common law partner staying within that residence would be whether domestic violence has been involved in the breakup of the relationship, or whether the court will find in the best interests to protect any children involved that a specific partner um, be ejected from the property. Common law partner of a sole owner does not have the rights to remain and may be evicted by the owner if there is no beneficial interest identified. To summarize, it's a very precarious position to be in as a cohabiting partner, where one partner has sole control of the property, even though that property may be internally considered as the marital home in the event of a dissolution in their relationship. The rights remain solely with the homeowner. So the best form of protection in that case would be to either push for a civil partnership or to be very confident that you can demonstrate clearly to the court that you have a beneficial interest in that property. Married couples enjoy what is known as the right to remain, or automatic home rights. Both married partners have equal rights to remain in the matrimonial home, regardless of whose name is on the mortgage. This is referred to as the home rights, and they are automatically granted at the time of marriage or civil partnership. This protects either one of the couple from being ejected from the home in the event of the relationship breaking down. Both sole and joint owners of matrimonial homes are unable to sell the property without the express agreement of both parties. Now, this might prove significant further down the line, where perhaps the homeowner in a particular marriage decides to leave the property and move in elsewhere, um, leaving the ex behind in the original property, and then chooses to attempt to evict said ex by selling the home. Um, the protection afforded for married couples will not allow this at that time. um, both parties must be protected from being ejected from a matrimonial home equally. The legislation that controls um, the property rights of married couples and civil partners involves the Family Law Act of 1996. This provides cohabitants the right to apply for occupation orders to the family home under certain criteria. It also allows courts to temporarily transfer property rights and impose any restrictions to interactions within the family home and surrounding area. This will allow for certain orders to be implemented, occupation orders, non-molestation orders, in the event that the situation within the family residence breaks down. The children and vulnerable individuals can be better protected. Further to that, the Children Act of 1989 provides the court with the powers to transfer ownership based on the best interests of the child within any relationship, providing the courts with the power to put the involved children as the top priority within a relationship dispute. Um, there should never be a time where a vulnerable child is put at risk by either the breakdown of a marriage or even a cohabitation dispute. As occupation orders, um, specifically regarding property and the protection of the family, victims of domestic violence can qualify for additional legal protection. Um, it doesn't necessarily mean you have to be married or a civil partner in order to gain the protection offered by occupation orders. Uh, the only qualifier is um, that you should be a victim of domestic violence. Um, any partner suffering from domestic violence can apply for an occupation order, in which the court will stipulate who has access to the family home and the surrounding area. There are 4 qualifying criteria before an occupation order can be granted. Number 1, that you own or rent the home, and it is, was, or intended to be shared with a husband or wife, a civil partner, a cohabitant, a family member, or person you're engaged to, or parent of your child. 2, you don't own or rent the home, but you're married or in a civil partnership with the owner, and you're living in the home. This is obviously known as matrimonial home rights, and we've covered that. Your former husband, wife, or civil partner is the owner or tenant, and the home is, was, or was intended to be your shared matrimonial home. Again, this reinforces the additional rights conferred to both married and civil partner couples above those afforded by simple cohabitants. For the person you cohabit or cohabited with is the owner or tenant, and the home is, was, or was intended to be your shared home. That is an important addition because it presents those who cohabit with essentially partial rights to demonstrate in the event of an occupational order application that that the home they resided in together was intended to be more than just a place of convenient residence. It was to be a shared home. It was to be a place they may be able to raise a family. Um, so at least in this capacity, occupation orders can be applied for equally by both married couples, civil partners, and those cohabitants. As with any matters regarding family and property dispute, it is always recommended to seek specialist legal advice. You could contact charitable organizations such as Shelter, the Citizens Advice Bureau, or seek a family law specialist either online or in person through companies and charities such as the Child Law Advice Centre from the UK. Thank you for listening, and I hope you enjoyed this presentation and brief breakdown on the different rights and legalities within both marriage and property and those afforded by cohabitants. Thank you very much.